Hello, my name is David Nachman. I'm one of the managing attorneys at the Nachman Pawani Zimochek law firm with NPZ Law Group, also known as VisaServe, with offices in New Jersey, Ridgewood, New Jersey, and in New York City. We also have an affiliated office in Mumbai, India, and an affiliated office in Canada. Today I want to talk to you about a question that we get very frequently from our clients with regard to what's called the Intracompany transfer visa. This is a non-immigrant visa classification, but it's a very powerful non-immigrant visa classification because it has something associated with it called dual intent. So it's distinguished from other types of non-immigrant visas, which are pure non-immigrant intent visas, which, as many of you may be aware, come under Section 214B of the Immigration and Nationality Act, where it's required that an individual demonstrate that they intend to return to their home country after their temporary stay in the U.S. So the L visa doesn't require that you demonstrate that you have a residence abroad to which you intend to return. It has something called dual intent. So first of all, let's draw a distinction between the L visas. There are two different types of L non-immigrant visas. One is called the L-1A. The L-1A is for managers and executives, and then there's something called the L-1B. And the L-1B visa is for individuals with specialized knowledge. So when an individual would come to, let's say, our firm, we might sit down with them and we may start to ask them questions about what their intentions are if they want to come to the United States. So let's say, for example, that they've worked for 1 full year within the last 3 years for either a branch office or an affiliate or a subsidiary of or a parent of a large multinational corporation. What we might do is we might offer them the opportunity to be able to apply for an L intracompany transfer visa. And then what we'll do is we'll take a look at what exactly they did for that multinational corporation. If they worked abroad in a specialized knowledge position, then of course what we'll do is we'll recommend the possibility of transferring to the United States as an L-1B. An L-1B transfers to the United States with an initial grant of 3 years, and then the possibility of extending that 3-year stay with a 2-year incremental extension. So that's a total of 5 years. The L-1A is a person probably who's worked for that multinational corporation abroad for 1 full year within the last 3 years in a manager or executive position. And of course, what do we use to show that an individual is in a manager or an executive position? Well, things like salary level, things like job description, things like looking at their things that they've done in the organization will help us to determine whether or not they are either going to be pursuing a intracompany transfer as an L-1A manager executive or as an L-1B individual with specialized knowledge. Now the L-1A is a very special type of transfer because what it does is it allows an initial grant of 3 years with 2 2-year extensions for a total of 7 years. But the reason why a lot of people look very specifically at the L-1A is because what they want to try to do is to move to a green card in what's called a pre-certified classification. So what an individual who enters the United States as an L-1A is able to do is to move their green card case through a pre-certified classification called EB-13 or multinational executive. And that gets them the green card on a fairly rapid basis. The non-immigrant visa application that's used, or petition that's used for an L1 is the I-129. If you're planning to do an L-1A, it's the I-129 with an L-1A visa rider. And if you're planning to do an intracompany transfer, individual with specialized knowledge, it's the I-129 form with an L-1B rider for an individual with specialized knowledge. Now there are many nuances to the L-1 visa classification. For example, there's something called a new company L-1A, and we're going to discuss that in another one of our videos. And also, the specialized knowledge classification or definition in the L-1B context is something that is currently being bandied about by the USCIS, and the definition has not been fully honed, although there is some regulatory guidance, but it's still sort of in a state of flux. So we're going to talk about that also in a different video for your ready reference. So I thank you very much for joining us today just to learn about the nuances of the L-1A and the L-1B non-immigrant work visas for entering the United States as an intra-company transferee. Thanks very much for joining us.